let's take a few moments to consider a few of the cases that explain the Free Exercise Clause and what constitutes a substantial burden. In these types of cases, you have to ask whether legislation has in some way violated the free exercise of religion by imposing a high burden on practice. There are actually a number of cases that have been decided that in some way at least clarify what free exercise requirements are, in terms of burdens of proof, and in terms of requirements of both parties as to what they have to present in a court case. The cases that explain this concept are actually not related to land use decisions, but they still apply because they define what free exercise is. Let's begin by looking at a case called Sherbert v. Verner, which addresses the substantial burden question. The plaintiff in this case, who is a Seventh-day Adventist, worked in an office where she was required to work on her religion's Sabbath. She was fired from her state job for refusing to work on this day. When Sherbert applied for unemployment benefits, she was denied because she left her job willingly. Remember, unemployment compensation is only for people who have been fired. So she sued, claiming that the denial of benefits was an unconstitutional infringement of her First Amendment right to the free exercise of religion, that it placed a substantial burden on her ability to practice her faith. The court held for Sherbert. It found that the state was forcing her to choose between the tenets of her religion and receiving state benefits. Essentially, she could have a job and not practice a part of her religion, or she could practice her religion and not receive her unemployment benefits. The decision said, to condition the availability of benefits upon this applicant's willingness to violate a cardinal principle of her religious faith effectively penalizes the free exercise of her constitutional liberties. This case provided the strict scrutiny test for free exercise cases, the substantial burden language that you're going to need to use in answering a free exercise question. What does this mean? Well, if a plaintiff believes their First Amendment rights are being offended, they would be required to demonstrate to the court that the government imposed a substantial burden on the free exercise of their religion, that it made it substantially more difficult to practice that religion. Then it would fall on the government to prove that the regulation served a compelling government interest that justified that burden. So first, the court considers whether a law has imposed a substantial burden on the practice of religion. The government then has to prove that the regulation serves a compelling government interest that justifies the law, and that no alternative form of law could avoid this type of infringement and still achieve the government's goal. This is what's known as the least restrictive means. What you would need to explain is how the religious practice has been substantially burdened, if there's a compelling government interest, and if so, what is it? And also, could the law have been more narrowly tailored so as not to impact religious practices? Let's take a look at another free exercise case called Wisconsin v. Yoder. This is a case where the Amish religion was being negatively impacted by compulsory high school attendance laws that were contrary to their religious beliefs. There was a law in place that was imposing criminal sanctions on Amish families for not making their children attend public schools. Forcing these people to send their children to public schools was alleged to be a violation of the Free Exercise Clause because it was contrary to their religious practices for their children to attend public schools. The court found that the compulsory attendance law had an impact on the Amish religion that was not only severe, but inescapable, because the Wisconsin law affirmatively compelled them, under threat of criminal sanction, to perform acts undeniably at odds with fundamental tenets of their religious beliefs. There are free exercise cases where there's not enough of an impact for there to be a violation, where it's been found that it's not unconstitutional to make religious observance more difficult or expensive. Consider, for example, Bernald v. Brown. This case addressed a Sunday closing law that made Orthodox Jewish merchants' religious observance more expensive. They had previously kept their businesses open on Sunday and had done a substantial amount of business on Sunday, which compensated somewhat for their having to close on Saturdays. Here the Supreme Court found that a person's religion is not substantially burdened by a statute that makes one's religious observance more difficult or expensive. You should also remember the Ling case from the previous module on Native American issues. In this case, various Native American groups challenged the construction of a paved road through federal public land, asserting the construction would harm sacred areas traditionally used for religious rituals, interfering with their free exercise. The way the court refuted the claim was to say that to prevent the construction of the road for the protection of the Native Americans' religious practices would be an Establishment Clause violation. So you can see it's striking a balance. Interference is not the same as impossibility. The court recognized that although the road would interfere with their ability to pursue their spiritual fulfillment according to religious beliefs, it didn't coerce the plaintiffs into violating those beliefs or penalize religious activity by denying anyone an equal share of the rights, benefits, and privileges enjoyed by other citizens. Finally, let's look at a case called Oregon v. Smith, which essentially changed the landscape in free exercise cases, where there are what are called neutral laws of general applicability. In this case, 2 people were fired for using peyote at a religious ceremony. It's important to recognize that using peyote was illegal under state law. So the conduct at issue in Smith, the ingestion of peyote, differed from the conduct at issue in Sherbert, refusing to work on Saturdays, because the conduct in Smith was illegal under state law. What the court does in Oregon v. Smith is to allow a lower standard of review in cases where the law is a neutral law of general applicability. This is called the rational basis test. The court said, the right of free exercise does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability on the ground that the law proscribes or prescribes conduct that his religion prescribes or prescribes. Under the rational basis test, which is a lower level of scrutiny than the strict scrutiny test, the government only has to show that a neutral law of general applicability meets a legitimate government interest as opposed to a compelling government interest to overcome a free exercise challenge. Once again, in Sherbert v. Verner, the law required an individual assessment for unemployment benefits. There was a decision made regarding her alone. In Oregon v. Smith, it was a neutral law of general applicability. It was illegal for everyone to take peyote. So in a free exercise case, you have the strict scrutiny test. The First Amendment is offended if the government imposes a substantial burden on the free exercise of religion unless a compelling government interest justifies the burden. Or the rational basis test, where it's a neutral law of general applicability and it meets a legitimate government interest. By now you're probably asking yourself, what do all of these religion cases have to do with historic preservation law? You're about to find out in the next case you read, called St. Bart's v. City of New York. In this case, an Episcopal church will challenge New York City's landmarks law as being in violation of the Free Exercise Clause. Thanks for listening.